It wasn't the first time the prosecution was conceding that the men's right to a fair trial in a reasonable time would be breached by an order for a retrial.
Jet told you so. Once again, the lawyers and Sir P have been exposing a lot of things in the cartel's retrial hearing. You know what? Let's jet into this story. Welcome to Jet. So first and foremost, before we get into how much is being exposed in this case, give thanks to Yahweh and Yahushua. Yes, man. The defense mount a strong argument in such man retrial case. They argued and conceded by the prosecution that the men's constitutional rights may have been breached.
It wasn't the first time the prosecution was conceding that the men's right to a fair trial in a reasonable time would be breached by an order for a retrial. But this time, the team from the DPP's office acknowledged that the concession was a hurdle to the retrial order they were seeking from the Court of Appeal. Prosecutor Lorianne Tugwell acknowledged the difficulty the prosecution faced soon after getting to her feet. Justice MacDonald Bishop commended Tugwell for her frank admission, pointing out that the prosecution needed to prove to the court that the acknowledged breach of the men's constitutional rights was justified under the Charter of Rights. The justice noted the prosecution would need to prove the justification with evidence. Justice MacDonald Bishop pointed out that the clock started ticking on the men having a fair trial in a reasonable time after they were charged in 2011. She said it would be incorrect to believe the starting point was March 2024 when the Privy Council overturned their convictions. In response, Prosecutor Tugwell noted that acquittal or dismissal of the case should be seen by the Court of Appeal as a last resort option. She said dismissing the case should only be an option in exceptional circumstances where a fair trial was completely out of the question. The prosecution maintains that a fair trial for Cartel and his co-accused was still a strong possibility if the case is sent back for a retrial.
I told you so. I told you so in this video here on your screen. Noria Bantan, reporting from Nationwide News, observing, admission, challenges, and the exposure of some of the weaknesses in the DPP's case. When a conviction is quashed, the convicts must be released. Confiscated documents for flight risk or rearrest if you have to, but they should not be kept in prison for fear of rights being breached. They should have been released. Yes, man. Release the man them pending the retrial hearing. But Uno never listened to Jet. This could have avoided this argument that is coming back to bite the prosecution.
During the morning session of Friday's hearing, Prosecutor Jeanette Forbes told the three-judge panel that sufficient safeguards existed to manage any risks that pretrial publicity may cause. Forbes urged the Court of Appeal to trust that an impaneled jury would take their oath seriously and not be unduly influenced. He says, despite the high publicity in the case, the judges should look at other high-profile matters in coming to their decision. Forbes highlighted the U.S. case of Bill Cosby and the South African case of Oscar Pistorius. Forbes said judges allowed those cases to proceed amid heightened publicity because of the interest of justice. Justice MacDonald Bishop appeared unconvinced by the comparisons, pointing out that each case had to be judged on its own merit. In closing the prosecution's case, Tugwell told the court that it was because prosecutors cared about Cartel and his co-accused why they wanted the case tried on its merit and not simply dismissed on a technicality. Final arguments in the case are set for Tuesday morning.
The prosecution put on a good rebuttal, but the judge, Miss Bishop, was not convinced. Jet agree with Miss Tugwell that in the interest of justice, every case should be tried on its own merits.
So, where do we go from here?
Manhattan prosecutors said that they are going to do everything they can to retry the case.
They can bring Mr. Weinstein back to New York and have the case put back on the calendar and bring the witnesses back and they would try a very different case without those other witnesses. There's a lot of different ways it could go from here.
As for witnesses in a Suchman case, the prosecutors can subpoena them to testify. Yes, Ms. Tugwell, many cases are highly published cases, but yet still get a jury trial, not to mention Harvey Weinstein and Ahmaud Arbery cases. Weinstein was convicted for rape, and Mr. Arbery was dirt by racist Greg and Travis McMichael. Jet is going to use Harvey as test case to look at Sir P's argument and the defense argument. Ms. Tugwell argued that Suchman and friends should not be given the opportunity to get off on technicality.
Did Harvey Weinstein just get off on a technicality?
The Privy Council could have freed the world sprat outright. The Privy Council could have freed the world sprat outright. They looked at the evidence. Even the Privy Council knows the world sprat guilty. But I'm telling about paperwork and technicality. A paperwork and technicality made this case get sent back to Jamaica. They would have quashed it outright. All that nonsense about phone this and the phone the tamper with Privy Council didn't even look on that nonsense.
Sir P, after the conviction Suchman was cleared from, was staged to circumvent the legal system to create another chance for Suchman should them convict him. Both the defense and the then parlor allowed the case to continue even though they knew of jury tampering, but was parlor tricked?
Mistakes were made. Basically, that both the prosecution and the court screwed up.
We knew that Harvey Weinstein did not get a fair trial.
And so, Weinstein's conviction in New York City now goes away.
The DPP, Paula Llewellyn, ma'am, with all due respect, it's over. She can't go on. Paula Llewellyn allowed Miguel Lauren and Tom Tavares them to play her like a gig 10 years ago. That's when she lost this battle, Tom Tavares, Finson, Miguel Lauren, and co. These devils set this up from day one. The President of the Senate. People set this up from day one. The Aquarium Squad will take the credit, but the entire plan was hatched by Tom Tavares, Finson, and co. This was set in motion 10 years ago. Michonne said he made it clear he was happy. Right, when time they get turned down by the Court of Appeal the first time, he said this is actually not that bad because now we can go Privy Council. They knew this was grounds to get the conviction quashed. 500,000, where the money they come from? You think a juror go in my account and take out $500,000 to get other people to save World Sprat? To save Vibes Barabbas? They knew it was a win-win situation. If they accept the bribe, then it's not guilty. World Sprat win. If they don't accept the bribe, guess what? Now they can say, oh dear, well, didn't get a fair trial because the juror tried bribe Monday. Oh Lord of mercy. They know the law well. All these loopholes are put in place. All these loopholes are put in place. So the people who know them can exploit them.
The prosecution and the defense broke the fundamental rules of a fair trial. Hence, the Privy Council quashed the conviction on technicality.
This is a messy case to make, and the prosecution decided to take a chance. Let's gamble by breaking one of the fundamental rules of a fair trial.
Both the Weinstein and Arbery cases were very publicized, but them still aired the case in front of a jury. No, in Suchman case, the defense is arguing the publicity will prevent a fair trial. Sean Storm's sister argued the same thing. Sir Pia said this will set a bad precedent if them refuse a retrial on this ground and open a floodgate for similar cases.
When the Englishman did come up with law back in the days, it wasn't for no justice and no fairness. Matter of fact, originally the law had punishment for doing things like this, the king. The law originally was set up to protect like the crown and everything. Stop it. Justice for all. Right. Tech time became that, allegedly. When I hear something, I don't think to myself, well, what the law? I ask myself the question, what is the logic behind this? It have to pass the logic test. Think about this guy. You can kill somebody on camera. Let's explore the jury tainting argument. If a case is so viral, as everybody see and hear about it, then the jury are got tainted and the person can't get quote-unquote justice. The person get justice, the defendant? Sorry, so make a look on this now. Sci-Fi kill Mikey. Then the Migla Spanish Town and he get catch on camera. The video go viral, pan viral, pan viral. Sci-Fi's defense argues because the video is so viral, everybody see it before we even reach a court. The jury pool tainted. The judge says, "You're right. You can go home, Mr. Sci-Fi." That's law for you. Okay, law is not neurosurgery, it's not astrophysics. You can kill a man on camera, but them can argue say, well, everybody see the video already, so jury pool tainted and our the jury send a court matter upon court day, so it done gone bad already, and the judge say no sorry thing. Everybody see it already, so the defendant can't get no justice, so Sci-Fi go home. So guess what? The man was dead, Mikey, him not getting no justice because apparently Sci-Fi not getting no justice. Operating on logic, on reason, and actual justice would be Mikey. But Mikey get where he don't get because Sci-Fi apparently never get no justice because him video go viral. Think about the precedents that can be set here. If Barabbas precedents get set, all that the case they can turn upon its head. Because this all started from a viral video of man end up get convicted of fight, guilty get 2 life sentence, turn witness. Your Honor, this all started with a viral video that kickstart the whole thing. Because from the video come out, what was the argument? Right away, the public ear was gone. Seymour Collymore husband, send man go kill her. That was the argument from day one. Collymore's defense lawyers can use Barabbas precedents. Hey, the case was so viral. That video was so viral and the argument was so viral and that ended up sink my client because the jury pool was tainted. Every man would then leak their own evidence. That means that the man will stab up his wife and kill her on camera and the camera in the house catch it. Him know say him gets him done for. You know what him have to do now? Release him own videos to the public. When that the video go viral, he go court go say, Your Honor, the jury tainted now because everybody see the video and people make up their mind already, so we're not getting a fair trial. And the judge say, well, in the case of Barabbas versus the Crown, that's what happened on jury tainted and the news that about it, and if a vlogger show the video, so a true your talk. Go on.
Big up yourself, Sir P. You are correct. If the retrial is decided on the basis of potential jury publicity, then that will set a bad precedent. You are partly correct in the creation of law, but the English legal system was created on the basis of property, the protection of land. Yes, man. If a man releases his own video for it to get viral, while Jet understand your analogy, that is too simplistic and cases are decided on its own merit and circumstances. Jet will be very surprised if a precedent is set here on the basis of the jury tainted logic. On day 5 of the hearing, the defense argued that the time it will take for a retrial would breach the men's constitutional rights.
The appeal court requested the reports to get a sense of how speedily matters sent back for retrial were being dealt with. Of the 2 murder cases remitted in the last 6 years, neither has actually had a retrial. Both are murder cases. The defendants have remained in prison awaiting a new trial date. The defense team for Cartel, whose given name is Adija Palmer, as well as Sean Campbell, Andre St. John and Kahira Jones, has urged the Court of Appeal to reject the state's attempt to retry the men for the 2011 murder of Clive Lizard Williams. A key point of their argument rests on the allegation that there is a backlog in the Supreme Court which would lead to further breaches of the constitutional rights of the men who have been in custody for at least 13 years. The attorneys say the breach would arise as a result of what they describe as an inordinate delay in the matter.
In previous videos, the acting DPP suggests a retrial could be by 2025. The Supreme Court report suggests the same time for a judge-led trial. which Jet believe could be one of the outcomes of a retrial. For a jury trial, it could be 2026, the defense argued.
The report from the Supreme Court indicates that judge-only criminal matters are being set for late 2025, while jury cases are being set for late 2026. RTEL'S team has indicated the men would be opting for a jury retrial if the matter was sent back for retrial. On Thursday, Acting Director of Public Prosecutions Claudette Thompson has estimated a retrial for the men could occur by 2025. The Supreme Court report says there is a system in place to ensure priority is given to certain cases. The retrial hearing is into its final day. The prosecution continues to make its arguments for a retrial of the men at this hour.
What? A jury trial? So them say, the longer the man stay in a prison, them rights breach, but prefer to go for a jury trial, which is a longer wait. This is what they call legal football. They cleverly indicated a way to strengthen their arguments for a breach of constitutional rights breach if a 2026. Them also, I said earlier in the video, remember the Sean Story argument and him sister? That a tainted jury will not justify a fair trial. So one would think they would go for the judge-led trial with a shorter waiting time. Is this what Sir Pia talk about? That the man them do with the bribing jury to open the door for another appeal. Anyway, the prosecution argued that the court listing could be expedited, speed up the thing. If them did listen to Jet and bail the man them, they wouldn't be admitting a constitutional argument in favor of the defense. Let's see how this will play out. Jet don't have a view either way. If the man them do the crime, them for do the time. If not, them for walk free. And that's the thing there. You hear that? Yes, man. So, what is your view? Do you believe the defense lawyers are exposed for making nonsensical arguments? Or is it just a legal trickery for the best outcome for the man them? Write your comments below, man, and let's have a discussion about this. For those of you who've forgotten to subscribe, please touch the like button, smash the subscribe button, and touch up the bell. And remember to share with your friends and family. So here we are going now. We are gonna jet off,